we've apparently sent a message to whoever controls the heating. Nothing's happened. So if you've all gone off to the shops and bought extra clothing over lunchtime, it's probably wise, but if something does happen, we'll all be too hot.
Yes. Certainly those of us in silk gowns and horsehair wigs are quite comfortable right now, but things shouldn't be done just for our comfort.
At last we found a reason for it.
My Lord, just before I pick things up where I left off and really wrap things up and hand over to my learned friend, Mr. Williams raised with me the possibility that it might assist the court to have sight of a blank claim notification form so that the court can see what exactly is said in the form about higher claims and what doesn't have to be said. Now, we don't have one to hand up now, but if it meets with the court's approval, perhaps we could send one in at the end of the day.
Because the document that did have that sort of detail in wasn't that. It was the similar document for one of the other protocols, wasn't it?
We have the court, we have the court pack in the supplementary bundle, but not the claim notification form.
Okay.
So we will provide that. Coming back then to the issues here. The question of transfer out, I submit, it really is a subsidiary issue because the real issue here is what was the evidential standard which the learned judge below should have applied, and did the claim meet that standard? Was she right to hold that the Deputy District Judge couldn't be criticised for not rejecting the claim of impecuniosity? And to the paragraphs that I showed the court before the short adjournment, I just need to add one paragraph of the judgment, and it's paragraph 40 back in the core bundle at page 72, tab 7, page 72. And paragraph 40, the judge said, I've already referred to the Phillips case establishing that this portal is not the forum for extensive disclosure of accounts, etc. I've already found that there was sufficient evidence in the claimant's witness statement to show that he relied on his limited income from his taxi to get by from day to day and pay his bills. That, in my judgment, was sufficient for the Deputy District Judge in this case to make a finding of impecuniosity. Now, I submit that there is a specific error in that paragraph in relying on Phillips as having anything to say about what sort of information should have been provided. The portal is, as I've said, silent and leaves it to the claimant's discretion, really, as to what they want to produce in support of their case. And what the learned judge seems to have conflated there is the question of disclosure, as we might understand it in a Part 7 sense, and the question of what is actually the evidential standard. What do you have to do to make good a claim of impecuniosity? And the standard which I submit should be applied in the protocol as outside it, and which the circuit judge ought to have applied, is that of Hussein, backed up by the other cases, bare assertions, or even as much as was said in the witness statement in this case, are not enough. And so my primary submission as to the disposition of this appeal is that the judge was in error in holding that what the claimant had done in this case, in those two short paragraphs of his witness statement, was enough. Now, if I am right about that, then it should have followed that the judge should simply have dismissed the claim, or rather, if one is approaching it strictly in Hussein terms, what she should have concluded is that the claimant had not made out a case that it was reasonable for him to incur the credit hire charges rather than claim his lost profits. That there was no evidence before the court of the lost profits, and so it could be said that what should have been allowed was simply nil, but I'm not instructed to take that course now. Our position is that we stand by the offer that was made at the time in respect of credit hire, which was some £1,800 odd, and therefore that if the court is with me on that submission, then that should be substituted for the order which was in fact made. If the circuit judge was entitled to hold that the evidence was sufficient to establish impecuniosity, then of course that decision can't be criticised. And so looking at those two possibilities, the issue of transfer out doesn't then arise. But I do submit that it's nevertheless open to the court to consider whether that would have been the right way to deal with it. And if I do need permission, if that's regarded as an augmentation of the argument below, and if I do need permission, then in my submission as a purely procedural consideration, with the effect of doing so now being no more than to put the claimant in the position he would have been had the judge done it then, there can't be any question of prejudice to the claimant. It's not a pure point of law, but it's close to it in the sense that it doesn't depend on anything that might have been done differently below. It's something which the judge might have done or might not have done. And so I do submit that it's open to the court, or we should be allowed to make that submission, that was one way of dealing with this. But the primary submission is what the learned judge should have done is just dismiss the claim as not meeting the standard.
It's your ground one, you say, is the primary.
In effect. I mean, the significance of transfer out is it probably goes more to the wider question of how do you deal with these problems.
Yes.
And as to that, of course, it's my learned friend really saying transfer out is the answer. I appreciate that he may be saying it's for the defendant to ask for it, but we say it's very much a subsidiary point in this case. So, my lord, those are, unless I can assist further, my submissions.
No, that's been very helpful. Nothing from you? No. Thank you very much, Mr. Carpenter. Yes, Mr. Williams.
Yes, may it please the court, regarding Mr. Carpenter's primary case, that practice under the protocol should be assimilated to that in practices, to those practices in cases prepared for and then determined at a traditional trial. We respectfully say that it's a transparent instance of defendants wanting the best of both worlds. Or to use a recently topical analogy, it's an exercise in both keeping the cake and eating it. So far as Mr. Carpenter's secondary case is concerned, which appears to be predicated on a timely objection to the Stage 3 process in the acknowledgement of service, which in appropriate cases would lead to a transfer out, but to proceedings not treated as small claims, but to proceedings where costs are recoverable. We don't disagree with that as a secondary solution, as will be perfectly clear from our skeleton. Though clearly I do need to address you in due course on what's said in Phillips and Willis, and obviously I do particularly stress the points that it would need to be founded upon a timely and reasoned objection to the use of Stage 3. And I also emphasise that Mr. Carpenter is quite clear in stating that where that happens, the cases would not be subject to small claims track cost rules. We're by no means sure that other defendants would make the concession that Mr. Carpenter makes, that if these cases do come out of the protocol and they're allocated to small claims, the costs are still recoverable. But that fortunately isn't a point that this court needs to decide. Now, the other point that I will make about the secondary cases is also we are somewhat sceptical as to the frequency with which defendants would in fact wish to give up the cost benefits of the protocol and expose themselves to the much higher measure of costs for cases which leave, which, as we say in our skeleton, and I don't think the figures are disputed, in this case would potentially have increased the defendant's cost liability by some 450%. It would be noted that in the present case, or I think the companion case, there was no application to take the case out of the protocol. I think in the companion case there was a very late reactive suggestion of that, but that was purely reactively to the late introduction of the new legal argument about the Hussein case. That certainly wasn't something which the defendant had sought. And there's no reason to suppose, we submit, that in either case that results from ineptness on the part of the defendant's insurers, rather than from a deliberate desire on their part, that they would rather retain the benefits of the protocol. There's certainly nothing to suggest that these cases were left in the protocol by accident or through a process of disregard. But if I could return to Mr. Carpenter's primary case, his client wishes to say that claims started and remaining within the RTA portal or protocol should be conducted and evidenced in the same way as claims which either began outside it or which leave it, whilst defendants should still retain the very significant cost advantages flowing to them from the protocol, together with the concomitant streamlining of the legal process. And in support of that, Mr. Carpenter showed you a series of cases, but as the court picked up immediately in its interventions, none of them were stage 3 cases. So we have cases like Umergi and Dereye, in which claimants have legitimately been criticised for not pleading or evidencing their cases on pecuniosity properly. But of course, as the court has seen, under the protocol, there are no pleadings. That is one of a series of shortcuts which have been introduced in the interests of economy and expedition. And your lordship and your ladyships were also shown the same cases, Dereye and Umergi, but also this time Hussein, where claimants were criticised for inadequate disclosure in respect of their means and breaches of directions concerning the documents which they needed to disgorge. But again, under the protocol, there is no disclosure stage. It's another one of the shortcuts, and there are usually no directions either.
So how is a case such as these two cases to be dealt with under the protocol? If there's been a credit hire charge and the inevitable case of impecuniosity is to be raised, how can that be incorporated into the protocol process?
Well, if I can just preface it with saying, and with respect, I know this will differ somewhat from some of your lordship's interventions in my learned friend's argument. We don't accept that impecuniosity actually does arise in these cases as night follows day. And again, to echo a point I made a few moments ago, in neither of these cases did either defendant serve any evidence indicating that the credit hire rate was in fact more than the basic hire rate. Now again, there is nothing to indicate that that results from ineptness. It may very well be they didn't serve evidence because they couldn't find anything which they thought was helpful. We simply do not know. But it cannot be said that as night follows day, impecuniosity arises in these cases. And I would also say this, even in those cases where it might arise, in many cases, it will simply be self-evident. Because this is not a narrow exception to the usual measure of damages for basic hire rates. It's a statement of the obvious that for an awful lot of working people, let alone non-working people, if you're suddenly completely out of the blue, deprived of your car, to go off to Avis or Hertz and pay up front out of your taxed income or your benefits for a replacement vehicle is actually going to be extremely difficult. So in many cases, impecuniosity or impossible. So in many cases, impecuniosity doesn't arise at all. In others, it will simply be self-evident. So the number of cases which actually require a sort of deep dive into a claimant's finances.
So assume
Yes.
that's right, which I readily do. These two cases did involve impecuniosity.
Yes.
How should they have been dealt with within the protocol in a way that, on Mr. Carpenter's analysis, is fair rather than unfair,
Yes.
as it was?
Well, our case is that if there is a consensus, as we say there was, that the case remain within the protocol, then I can't speak to the detail of the other case. But in our case, as your lordship has seen, there was a statement by the claimant in which he asserted that he was a self-employed taxi driver. His income was wholly consumed by his outgoings, and he wasn't. And he essentially, I paraphrase, but essentially, he couldn't afford to give up work. In our respectful submission, I mean, that is evidence. It is evidence verified by a statement of truth on pain of contempt proceedings if it's falsified. And what one needs to be careful with in these cases is not to conflate the burden of proof, which of course I accept remains on the claimant, but also the standard of proof. The standard of proof cannot be the same in my respectful submission in these highly truncated proceedings, as they are, where defendants have the concomitant advantage of the massive cost saving, as the standard of proof that would be required in a different sort of proceedings. And if a defendant wants to say, well, in this case, I do have legitimate grounds for delving into the claimant's finances, and I'm willing to take the cost consequences, then the solution is, we say, is a timely statement in the acknowledgement of service, that we say that this case is not suitable for stage 3 because there is a substantial dispute of fact. And it is also, and what Mr. Carpenter is proposing, I'm going to come on to various reasons why I say it's unfair, and I know the court already is alive to how I say it's very unfair to claimants because it puts them to substantial work in circumstances where any derisory costs can be recovered. But one also is left, as it were, sucking one's pipe at what Mr. Carpenter proposes when you simply ask, well, how would it work practically? Because Mr. Carpenter, with respect to him, sort of breezily says, oh, it's just a simple matter. You put in bank statements for 3 months before the accident until the end of the hire. You have to put in your wage slips and such like. But it's perfectly obvious that for very many people, that's going to be a very substantial body of material. You might have, and it's not just bank statements, the standard directions which we see in the multi-track cases and the fast-track cases. They require credit card statements, savings accounts, there may be joint accounts. Mr. Eastwood, who sits behind me, who's got a great deal of practical experience of these matters, tells me it's absolutely routine in simple fast-track trials for this to give rise to hundreds of pages of disclosure, and in some cases an entire bundle of disclosure. Now, how is all that to be assimilated and analysed by a district judge in a 15-minute hearing where there is no cross-examination and only time for extremely short speeches? I mean, so even if the material is disgorged, the stage 3 process simply does not afford any opportunity for it to be judicially analysed. So from that perspective, well, I venture to suggest that what Mr. Carpenter is advocating simply doesn't work as a matter of practice, quite apart from the other objections which I say are relevant to it.
But to follow it through and to follow up the answer you were giving to my question, how should it be dealt with? It would seem that it should all be flushed out in stage 2.
Yes.
Your client, as your client did in this case, puts in his statement.
Yes.
Raises the bald assertion. If the defendants are unhappy with that and want to challenge the consequences of that in terms of the damages, then they ask for more details.
Yes.
Then the great batch of bank statements or whatever
Yes.
come out in stage 2, and hopefully the matter's resolved.
Indeed.
At stage 2. But if not, it's been distilled down by the time it gets to the district judge in stage 3. It's likely that the basic stance of each side will be known, and the district judge can work on that. But it's stage 2 is how it's accommodated.
And of course, another possibility is at stage 2, and if stage 2 leads to a sort of proliferation of material in the way that I've described, at that point, of course, as Mr. Carpenter showed you, there is a provision that says the claimant can say this case has ceased to be
too much.
Ceased to be appropriate for the portal. It needs to come out, and of course, the claimant can at that stage say, if you really want to have a deep dive down into my finances like this,
it'll cost
you have to put your money where your mouth is.
Yes.
So from that point of view. Those are all legitimate points, and of course the question often is, does the defendant want to put its money where its mouth is? And that takes me back to where I began, where I say really there's an attempt to engineer in these cases is a having of the cake and eating it, because they want to keep the stage 3 benefits whilst advocating a sort of forensic analysis of disclosure which is simply inconsistent with the process in question in our respectful submission.
Thank you.
It's not only inconsistent with the process, it's inconsistent with the thinking that upon which the process was based.
Yes.
Which is to have this, dare I say, streamlined, to use your word, truncated process.
Yes. Yes.
Where you have very little disclosure, you rarely have directions, and it is to move the matter through on a very limited cost basis.
Well, my lady.
It's just undermining that very.
Well, my lady, yes. And as I say, if one focuses on the streamlining, what we have to remember is this is a process that's been introduced to really as a substitute for what previously would have been fast-track trials. Now, I suspect there would be few district judges, however efficient and brisk, that would commonly have got through 2 fast-track personal injury trials a day. These matters, they can have a back-to-back stage 3 list, and they might get through a dozen of them. So, and it's simply inconsistent. And there's obviously, now, I mean, what really all this is a translation in policy terms of Voltaire's famous observation that the best can be the enemy of the good. Of course, the best thing is to have a traditional trial, but that may be the enemy of the good if in these small cases, scarce judicial resources, quite apart from the cost of the parties, are being wasted on disputes about, as in this case, the difference between £1,800 and £7,000 odd. It's a relatively small. It's a relatively small sum. So that is the sort of there is a sacrifice for efficiency, and if you don't want partake in the sacrifice as the defendant, as Mr. Carpenter has accepted in his speech, the solution does lie in your hands because you can always object. Quite apart from the fact it's really for defendants' participation in the protocol is always voluntary, because all they have to do is decline to admit liability or decline to make an offer in the process, and it comes out straight away. And Mr. Carpenter says, well, that would be a breach of the duty to cooperate. But the only sanction for a breach of the duty to cooperate is that you come out of the process. And if that's what the defendant wants, then it's not a sanction at all, it's a vindication of what it was trying to achieve. It's obviously the case that, in fact, huge numbers of cases do come out of the protocol because defendants do decide not to admit liability or not to make an offer. So they have that as a self-help mechanism, which is why they don't need an express facility to take matters out in the way the claimants do. And then if they don't do that, then they still have got their acknowledgement of service at stage 3, whereas Mr. Carpenter shows you at that stage they can object to stage 3 as being a suitable tribunal for the just resolution of the issues raised in the particular case in question, if, as I've said, they're willing to put their money where their mouth is.
Thank you.
I think I was referring to the cases that my learned friend showed you. And if I can, I expect the court picked up on this as he looked at Hussein. But of course, what Mr. Justice Pepperell says in Hussein, that's a case, tab 9, page 161. The paragraph Mr. Carpenter turned up. He says, what Mr. Justice Pepperell says, and I'm taking it just after the reference to Langton and O'Connor, paragraph 17. Any claimant wishing to justify higher costs on this basis will therefore have to comply with the directions given by the court in respect of the disclosure of documents as to his or her income, outgoings, assets, liabilities, etc. So what Mr. Justice Pepperell is saying is, and I take no issue with it, with respect, is predicated on this being a case which is going to trial where there is an obligation for direction, for disclosure, in respect of which specific directions have been given. And at paragraphs 18 and 19, the learned judge, in fact, identifies the directions which were given in that case, which was essentially directions for specific disclosure of documents relating to Mr. Hussein's financial circumstances, as a result of which Mr. Hussein was in fact debarred from asserting his impecuniosity, and that was the short answer that the judge found to Mr. Hussein's unsuccessful appeal. I'm not going to take you back to both of Umerji and Dirire, but if I can perhaps just show you the second of those cases. So that is tab 10, it's the next tab, paragraph 6, which is at page 165. That too is a case where you'll see at paragraph 6 there's an indented quotation of the directions that in that case were made. So it's a fast track. It's listed for a trial, not a stage 3 hearing. The district judge Walder made a debarring order, which fleshed out in very detailed terms what the claimant had to do. He had to serve a reply, so that's a pleading we don't have at stage 3, setting out all the facts, etc. he relies on. Then he has to give. He actually has to give inspection of documents, including wage slips or income, bank and credit card statements, 3 months plus the hire period. So that, as was Umerji, is a case where the court has given specific directions. But as Mr. Carpenter accepts, there is nothing analogous to that in stage 3. And for the reasons I've already offered, it's very difficult to see how there could be. Quite apart from the cost issues and such like that would arise, even if this material was produced, how could it usefully be deployed before a judge at such a short hearing? So all of this in our submission is a matter of design. This is a highly abridged procedure to reflect highly abridged costs. And I also do make, with respect, this observation. My learned friend comes up with the lovely phrase that it's an island of injustice with a large population. But if I could respectfully build on his metaphor, if it is an island of injustice, it's been built on reclaimed land, and its reclaimed land that, as Mr. Carpenter recognised, has largely been reclaimed in the interests of defendants themselves as part of the Jackson reforms, which were intended greatly to reduce the burden of costs which they face. Mr. Carpenter accepted that these rules are the product of industry negotiations, which I'm sure he would likewise accept. The liability insurers have a powerful voice. It's in fact the liability insurers who actually fund the online portal process. It is not funded by the MOJ, the insurers fund it. So if there is an island of injustice, it's a bit like one of those islands the People's Liberation Army has constructed in the South China Sea. I mean, it's been constructed with a strategic purpose and is generally to the advantage of defendants. As Mr. Carpenter repeatedly recognised in saying, in general, it is claimants who generally benefit from leaving the portal and not claimants, and not defendants. But what we have here is a defendant who doesn't wish to take the rough with the smooth. Now, so far as the rough is and the smooth is concerned, that in our respectful submission is expressly recognised by the architect of this system himself, Lord Justice Jackson, in the Phillips case, which your Lordship and your Ladyships have at tab 7. I know you've visited it before. I did just want to invite you, it's a passage I'm sure you've come across quoted in your pre-reading in a number of places, because it is nearly always quoted in the subsequent case law. It's paragraph 9 at page 116.
Sorry, which tab?
Tab 7, my lord.
Thank you, you did say.
Page 116.
Thank you.
And his lordship there says, if I can take it up in the second sentence on the right-hand side of the page, the practice direction substantially modifies the Part 8 procedure so as to make it suitable for low-value RTA claims where only quantum is in dispute. This modified procedure is designed to minimise the expenditure of further costs and in the process to deliver fairly rough justice. This is justified because the sums in issue are usually small and it is not appropriate to hold a full-blown trial. The evidence which the parties can rely upon at Stage 3 is limited to that which is contained in the Court Proceedings Pact. The Court assesses the items of damages which remain on dispute either on paper or at a single Stage 3 hearing. So it's a recognition that if you stay in the process, there is a certain rough justice. And of course, it's a rough justice that cuts both ways. The defendant doesn't get, if you'll forgive the cliche I've already resorted to a couple of times, the deep dive into the evidence that it would get at a trial. But on the other hand, the claimant's ability to recover costs is highly constrained. And of course, that is an important constraint because these are ex-hypothesized claims where liability is admitted. So there are cases where, if not quite as night follows day, then almost as inexorably the claimants recover their costs, unless, for example, they fail to beat an offer of some sort. And so that constraint on their ability to recover costs is the compensating advantage that defendants have for the truncation, the streamlining, or however you choose to label it. I will, just so I don't have to turn it up again, at the end of my submission, when I come to my learned friend's specific criticisms of Her Honour Judge Sykes' judgment, he says that at paragraph 40 she goes wrong because she refers to Phillips and Willis as being somehow relevant to the quality of evidence which is to be expected at Stage 3 hearing. I say with respect to him, he's quite wrong about that. It's perfectly obvious in my respectful submission that in the reference to Phillips and Willis, Her Honour Judge Sykes had that passage I've just shown you in mind, which makes it absolutely clear that there is a rough justice and the quality of evidence and such like it's just not going to be the same within the process. And so, well, obviously, I don't criticise my learned friend for discharging his duty, but I do say it's a rather unfair point to make about Judge Sykes' analysis. It's perfectly clear in my submission what it was that she had in mind.
Either now, while we have Phillips and Willis open, or at a later stage, are you going to make a submission about the White Book commentary?
I am, yes. I was going to come to that when I sort of deal compendiously with the points about referring out, and it certainly is. But just as a foreshadowing, I obviously accept that what the White Book says is probably factually correct in the sense it will only be the vast majority of these cases don't need to come out of the portal. I mean, remember, the portal is mostly directed at personal injury claims. It's really happenstance whether there's a credit hire case as well. And very large numbers of personal injury claims are bought by passengers in cars, so they're not going to have hire charges. So there's only a minority of these cases that will have higher charges. So you have that straight away. And obviously lots and lots of these cases can be dealt with within the portal. So to that extent, it may be the rare or exceptional case that comes out, but I accept it's not jurisdictionally part of the rule. There is nothing in the rule that suggests the court is exercising anything other than a normal case management discretion, which will be informed by the overriding objective.
Thank you.
In which the court will, of course, take the interest of will take the views of the parties into account, and to answer a point that my lady put to Mr. Carpenter, I certainly do say that the court would have to canvass the parties' views on the issue. But obviously, the court will also take into account the other sort of classic elements of the overriding objective as well, balancing the need to do justice in individual cases against the proportionality in the interests of court users as a whole. The one point that I will have perhaps make when we do have the Phillips case open is a paragraph 35, which I'm so sorry, Mr. Carpenter, he's not Lord Carpenter yet, showed you, I think. There is one, I suppose, gloss which can be attributed to Lord Justice Jackson rather than to the editors of the White Books, where I appreciate it's in the context of a general discussion about higher value, higher cases. He says such cases might involve complex issues of law or fact which are not suitable for resolution at the Stage 3 hearing. So that perhaps gives some insight into the fact it doesn't follow in my submission the mere fact a defendant asks for transfer that it's granted as of right. You have to persuade the court that it's appropriate, and it might not be appropriate.
But if a defendant had to show that this was a rare or exceptional case, that process itself wouldn't fit into a 15-minute hearing before a DJ in a busy list.
Yes, well, of course, I would say
if you got near to saying
yes.
that, it would.
If they want to say it at all, obviously, I would say they have to say long before the hearing. In fact, to say it at the hearing is exactly what it's not exactly the error corrected in Phillips, because in Phillips it was rather bizarrely the district judge that decided it was too complex against the wishes of the parties, but it's very close to the error which the district judge was found to have made in that case, because by that time all the costs had been incurred and there was no saving to be made. But I'm not asking the court to. It's certainly not part of my case that the court should approve the editorial commentary in the White Book. It has got to be a matter of case management discretion, exercised in accordance with the overriding objective.
Yeah. Thank you.
So I'm just, there was a certain amount of my notes that I've in fact preempted in answer to questions, so if you could just indulge me for a moment. Yes, I was going to then come on to the cost consequences. But in fact, before I come on to that, just to draw together what I've been saying about the abbreviated nature, the next abbreviation is also, of course, the fact there's no cross-examination or oral evidence at all. And again, to suggest that if you get what may very well be several months of a party's financial affairs and that party asserts they're impecunious, that isn't in a lot of cases going to give rise to cross-examination type scenarios. Again, well, I mean, any district judge who actually deals with these matters as trials, I have little doubt would tell you, well, I mean, it's what most of these trials end up being about. Well, could you have afforded not to go to Nando's that evening? Could you have afforded not to go to the cinema? Couldn't you have afforded to have borrowed? Couldn't you have borrowed your cousin's car? It's points like that. So it's not only the issues that I've suggested about the volume of this material, it's also that it almost inevitably gives rise to follow-up questions, and that rapidly takes you to a need to cross-examine, which you simply can't have in this forum. So we say that given these practical limitations, it's inevitable that if you stay in the protocol, what claimants and indeed what experts say is generally going to be taken at face value. Now, obviously, if it's not going to be taken at face value, then on the face of it, if you as a defendant you want to say, well, you should reject that contention, particularly where the contention isn't intrinsically implausible, it's going to be necessary for them to apply to take it out in our submission. Or if they don't do that, then they're just going to have to accept that while the burden of proof is the same as it always is everywhere, as I've said already, the standard of proof isn't the same. Then, of course, and I know I've been dancing around this, there are the cost consequences. And the points really are too obvious for development. As I say in my skeleton in its common ground, at stage 3, a solicitor's fee for preparing the case is £250, small uplift for London waiting. Now, again, with respect, Mr. Carpenter sort of airily says, oh, well, the client can be left to do all the donkey work. But that simply is not correct. Obviously, if material comes in and in essence a disclosure regime is being replicated, it's up to the solicitor has the usual professional obligations for a solicitor who is disclosing documents. And quite apart from the fact there is going to be a need to consider and analyse the documents in order to give their client advice and to determine the merits of the case. So, of course, there are cost consequences. Sadly, it isn't just as simple as impeccably organised claimants all having the documents readily to hand, which they give to their solicitors in apple pie order anyway. So it does have cost consequences, which can't possibly be fairly remunerated by a fixed preparation fee of £250. Now, Mr. Carpenter's riposte to that is to say, oh, well, you can see that that isn't a policy concern, because this regime has recently been extended to the small claims track, and on the small claims track you don't get costs at all. Now, I will not deny that when I first saw the protocol that Mr. Carpenter showed us this morning, my reaction was perhaps not that dissimilar from my lady's. And it does seem a rather extraordinary regime to have introduced for litigants in person. But for present purposes, one doesn't need to get into whether it's a wise piece of drafting. The key point is it exists for litigants in person. This is a regime where, for good or for ill, Parliament has decided the costs will not be recoverable, and claimants have to act for themselves. And if they want to go to a lawyer, that's a luxury choice. That is not the case with this regime. This is a regime where Parliament has made the opposite decision. Parliament has decided that it is reasonable to be legally represented, and you ought to be able to recover the reasonable and proportionate fixed costs of it. And its fixed costs is subject to two regimes. The one regime, which is the much less generous return, is predicated on there being this extremely brief hearing, if there's a hearing at all, without disclosure, without pleadings, without statements. And the other regime is based upon there being ultimately a traditional trial. And again, I make the submission that if you are essentially putting claimants to the work of claimants preparing for a traditional trial, then it cannot be right that by sort of shoehorning that nonetheless into the protocol stage 3 process, they are only able to recover the cost of a measure of representation which cannot possibly be adequate for the work that would need to be done.
Sorry, Mr. Williams, this is just a small point. Is this a choice by Parliament or a choice by the Rules Committee?
You're quite right, my lady, in the civil procedure rules which actually fix the costs,
yeah.
And it's the civil procedure rules that have that actually provide that Part 20 that small claims are not cost bearing, because that's a rule. Yeah. And the civil procedure rules are statutory instruments which, from memory, are subject to the negative resolution procedure. Right. So they are attributable to Parliament, though I suspect we all know that in the real world the amount of parliamentary scrutiny is probably relatively.
That's helpful.
We perhaps don't need to be forced to choose an adjective that might appear disrespectful for our supreme legislature. So the protocols themselves, I think, are made by the Rules Committee. Yeah. But I'm not 100%. I'm not sure. I'm 100% confident of their provenance, and if that's anything. If the court would like to be assisted on that, I'm sure that's something we could look at overnight.
I don't think it matters much.
So if we come to the present case, as I've said, there was evidence. It was supported by a statement of truth. We've seen the letter of the 4th of June, which comes after the statement. That letter of the 4th of June does not engage with the statement, doesn't impeach it, does not suggest that it is in any way inadequate. And nor, in fact, in the final comments, which we can see on the court pack, is there any reference, in fact, to impecuniosity at all, or the quality of evidence. And nor is there anything, and I know I've touched on this already, but in our submission there's nothing in the evidence which is intrinsically implausible. Because we do ask rhetorically, and without wanting to make sort of social prejudgments unnecessarily. But as a generalism, how many minicab drivers out of the blue, so not as with a pre-arranged holiday or something, but simply out of the blue, could simply be expected to forego any income for 3 weeks, just wait there, not earning, and bring in arrears a loss of profits claim. So of course, if what the statement had said it was obviously fanciful or something of that sort, then even at stage 3, no doubt it could be impeached. But what we have here is there is evidence, it's supported by a statement of truth, and it is not remotely implausible. And its lack of implausibility in our submission is manifested by the fact that no questions were ever asked about it in the letter of the 4th of June, and nor is it the subject of adverse comment. And yet, at the point of adverse comment, I mean, that was the point, the latest at which the defendant in our submission should have turned its cards face up. As I think really my learned friend essentially accepted. Just a few other points before I come on to the to the specific disposition and the sort of procedural points about the change of position which we say has occurred in this case. As Mr. Carpenter said, we're going to put in the claim notification form just so the court understands why that's coming. Partly we just thought it would be helpful for the court to just see holistically how this works. Yes. But secondly, and I think it does feed into some of the questions that were asked this morning, although, as we've seen, the protocol anticipates that vehicle damage claims may initially be dealt with outside it, the claims notification form does still require claimants to tell a defendant whether or not there is a hire car, who is providing it, and such. Like even, in fact, provides for a facility for the claimant to ask the defendants to supply them with a hire car if they need one. And it does ask quite a lot of questions. So you'll see it is. So it's not something that comes to defendants completely out of the blue. Even at stage 1, they've got information about this. What the claims notification certainly doesn't do is require a claimant to indicate any sort of position on impecuniosity or whether it's asserted or provide any sort of particulars. Now, I think the next theme I was going to come on to, but again I've largely anticipated, is what does a defendant do if a defendant wants to take a case out of the protocol. And as I've already suggested, there are actually various ways in which you can always take a case out simply through adopting a passive position in response to the various stages. The submission I was going to make about how it can take it out or apply to take it out at the acknowledgement of service stage, Mr. Carpenter has accepted that and he shows you the acknowledgement of service, and there's nothing in what Mr. Carpenter said there that I disagree with. Subject to the point that obviously they do have to satisfy the court that is appropriate as an exercise of case management discretion, as I've said already. And that will essentially be balancing things like, well, what's the value of the case? As Lord Justice Jackson says in Phillips, some of these cases will involve very substantial higher charges. The emerging case is one. And one imagines that in many such cases, if a defendant can show there are substantial grounds for defending the quantum which can't satisfactorily be addressed in a short hearing, then the defendant may experience little difficulty. One can imagine there may be other cases which are very small or such like, where a court might just say, no, the game just isn't worth the candle. This is part of the sacrifice that has to be paid for this streamlining from which defendants across the board generally benefit. And I'm no sense inviting the court not to give guidance to the industry. I know that it would be extremely helpful, but I know the court will recognise that ultimately the guidance that can be given can only be at a relatively high level, because precisely how you exercise a case management objective, a case management discretion, applying the overriding objective will always be fact sensitive.
Yes.
So if I can then come lastly to the shape of the appeal and the decision of the courts below. The first point I make is though I do with respect say that Judge Sykes' judgment is admirable and discloses no error. The ultimate question, in fact, is the Deputy District Judge's judgment. That is made. I mean, in my respectful submission, that's clear enough from first principles. Because when one's asking is Judge Sykes right or wrong, one asking was she right or wrong not to interfere with the learned deputy district judge. But we also have it from the recent decision of this court. Again, it's Durier. I hope I'm pronouncing it correctly, but I'm not sure I'm pronouncing it consistently. So I can't always be pronouncing it correctly.
You're right on your second point. So.
It's tab 10, and it's tab 10. It's paragraph 17.
Thank you.
Page 167, Lord Justice Coulson. Permission was granted for a second appeal. Of course, in cases where a circuit judge has upheld the decision of a district judge, it is the original judgment, here the judgment of the DJ, that must be the primary focus of the second appeal. And he cites Lord Justice Lewison, in the Surrey and Barnet and Chase Farm case, which is a case from memory of out appeals from cross judges, as it happens, but he's clearly making the point more generally. So it is the deputy district judge's decision. Now, I do say that so far as the point about the quality of the evidence is concerned, I do say it wasn't actually pursued. It certainly wasn't pursued adequately. Just to try to make that good, if I could take up the transcript of tab 1 of the supplementary bundle. Mr. Carpenter showed you the passage at the top of page 5. And this is Mr. Bradley for the defendant. And what he says is, so he begins by saying, in my submission, the claimant was notified on the 2nd of January that an alternative vehicle was offered. So that's what we've called in shorthand the Copley point, or the intervention point. That is, you failed to mitigate loss because you did not accept an offer from the defendant of a replacement car. That point is rejected by the district judge, and the judge is not renewed. So it's in the context of that Mr. Bradley begins this submission. And it is then true, he goes on what, if I may say so, was a doubtless effective rhetorical flight, where he makes the point that for the claimant, for there to have been a successful cost-benefit analysis of the claimant's decision to hire, he would have to be a very well-paid taxi driver indeed, and that is the series of figures which he gives, and he adds VAT, and it says it comes to an annual income of 83,000. And he says the whole point of my putting those figures is that would not be a reasonable mitigation of loss, because this is alleged to be an impecunious taxi driver. So if that was the question, I agree with Mr. Carpenter. It would be appropriate for him to pursue a loss of earnings claim. But then he says in terms, and Mr. Carpenter jumped over this, but that does not arise in this case because the alternative vehicle was offered. You then get a sort of mishmash of other points, including a reference to financial accounts, which I don't think anybody's ever worked out what Mr. Bradley was referring to about financial accounts, because I don't think there's any suggestion that there were financial accounts. So that's a bit confusing. But whatever it is, he says in terms of the points he's just made about income don't arise because the alternative vehicle was offered, and all of the rest of his submissions are about the alternative vehicle. Then when Mr. Seed replies, and Mr. Carpenter showed you this at paragraph 7, I don't, with respect, read Mr. Seed in quite the same way as Mr. Carpenter, and I appreciate it's unsatisfactory that we're sort of passing submissions being made by counsel in this way, but there it is. And what Mr. Seed is saying in my submission is he's essentially saying, well, Mr. Bradley's identified a really bad point. That's the euphemism. It's an interesting argument. That's the claimant, should have just sat on his backside and not gone out and earned a living. So, I mean, Mr. Seed is pouring scorn on it as an interesting argument. But he says in terms of, my learned friend does not advance it. It's an interesting argument that my learned friend does not advance. And then he appears to say, my learned friend does not, something that's inaudible. So Mr. Seed is clearly saying he's not taking that point. Mr. Bradley doesn't suggest that he's wrong about that. The judge gives judgment. As we've seen, the judge does not deal with the point about loss of profits or impecuniosity. Mr. Bradley does not tax the judge with his failure to address a key point that he's made. On the contrary, Mr. Bradley asked for permission to appeal, and his request for permission to appeal, you have that at page 8. And Mr. Seed is saying, my learned friend does not advance it. It's an interesting argument that my learned friend does not advance. So it's in the context of that Mr. Bradley begins this submission. And it is then true, he goes on a reference to just precisely in the centre of the page. I asked for permission to appeal. It's a point of principle of what is effectively the evidence. The burden is on the claimant to prove he has properly mitigated his loss. The alternative vehicle was offered before he took his hire vehicle. The burden is on him to say whether he investigated all those issues. And then they're submitting whether that's the point of principle which you should grant me permission to appeal. So the permission to appeal application is also just based upon what's been called the intervention argument. And it is right that Mr. Bradley expanded his point on first appeal, and my predecessor attempted to meet it by really saying, well, the learned judge dealt with this implicitly. But I do say there is another answer, and that because, as I've sought to show, we are here concerned with the rightness of the Deputy District Judge. The Deputy District Judge was not wrong on this point because it wasn't pursued, or if it was pursued, in no sense was it developed in any way, and even allowing for 15 minutes. I mean, on the contrary, the point is specifically said not to arise in this case because of the offer of the alternative car. I would also fortify it with reference, still in the supplemental bundle, to the ultimate statement of the case for the court to determine in the stage 3 proceedings, and that is, of course, the proceedings pack that is at page 50. So it's tab 4, page 50 of the supplemental bundle. So if one looks at it horizontally, I'll just pause while my lord.
I got the wrong one.
Forgive me.
I have the right one. Yeah.
Yes. Car hire. So the car hire case is stated, and the defendant's response, they offer £1,881. And they say, our offer of £1,881.46 is maintained, and we refer to our previously attached correspondence. And the previously attached correspondence, that is the letter of the 4th of June, which we've got in the previous divider. But I mean, it is right to say that letter makes a number of points, including at one point it does refer to the issue about loss of profits. But the offer itself is entirely predicated upon you should have accepted the intervention. And you get that on the second page of it. We're offering 19 days at £82.52, and that's a reference to the intervention. And if the defendant was saying you actually don't get anything because you haven't proven that you've got a higher claim, you should have brought a claim for loss of profits. Obviously, what the defendant would then have done is to say defendant response higher charges is 0. There is no claim for higher charges. This should be a loss of. The claimant has not proven this isn't a loss of profits claim. They haven't done that. So when you have that quasi-pleading type document, closest we have anyway, and you then cross-reference to that to the shape of the argument before the Deputy District Judge himself in our submission, this point simply wasn't before the court. But if we're wrong about that, then we say with respect that Judge Sykes is absolutely right to affirm him. Within, and I've made my points about that already, within the context of this truncated procedure, the witness statement was enough. Particularly in circumstances where the defendant had not, in any cards face up way, joined issue with it. My lord, my ladies, I think that just leaves me with the limit of appeal about the judge should have transferred. Again, although in the debate between my learned friend and the bench, the focus was on what Judge Sykes should have done. Of course, what all Judge Sykes had to do was, if this point was there at all, was decide whether or not the Deputy District Judge acted in a way that no judge reasonably could in failing to take this point of his own motion. And in my respectful submission, with great respect to my learned friend, it is forgive me if the language is, but it is a hopeless point. That would be Phillips and Willis. The district judge on the day of the hearing, when both parties had turned up in front of him, not wanting, neither of them asking for the case to be transferred out, should of his own motion have transferred it out. But that would be precisely the mistake which this court corrected in Phillips and Willis. So although I know this court is not assisted, however satisfying it may be at the bar, by excessively energetic language, I do say it is a bad point, really for that reason alone. But quite apart from it, even if it didn't face the impediment of Phillips and Willis sort of glowering in its path, the simple fact remains is ours is an adversarial system. And to say the Deputy District Judge was wrong not to make an order that neither side asked him to make, in my respectful submission, it is simply not a tenable proposition. I'm not going to take up time as to whether or not really my learned friend needs permission to raise the point. I do in fact say that he does, and I do say it's clear it is not answered by the permission to appeal point. You do need permission to raise the new points in this court, and we have included in the authorities. I give it more for your lordship and your ladyship's note than inviting you to turn it up. It's a very recent case at tab 12 called London Borough of Brenton Johnson.
Is that in your skeleton, or is it?
It's only in the replacement skeleton which we put in a few days ago. So depending on whether or not
I've seen that. I took the skeleton.
Well, in that case, I'll break my promise and I will briefly turn it up, just so your lordship knows where to find it. It's tab 12 of the authority bundle.
Thank you.
In the it's page 204. And paragraph 37, and I think it's Lord Justice Lewison, it is. First of all, he says, citing a previous case, that permission to appeal does not preclude the respondent from advancing procedural objections to new points. And quite apart from the authority of Lord Justice Lewison, I say that must be right, because permission to appeal is an ex parte process, and whether or not to introduce new points must be ultimately an inter partes matter on which a respondent is entitled to be heard. And then the Lord Justice Haddon Cave is quoted as setting out principles for new points. And of course, I do accept that subject to cost protection, if a totally new point of law is taken on appeal, this court does at least sometimes let it in, particularly if it's a point that's perceived to be important. But this isn't a point of pure law. This is a point as to how the learned Deputy District Judge should have exercised the case management discretion. And I do say that as a matter of law, that is not the same as a pure question of law. It's a matter of case management discretion. My client, if this point was to be taken, my client was entitled to the filter of the first instance judge who's entrusted with the case management discretion to decide how to exercise it. And I know the court will, I mean no disrespect to it in whatsoever, when it may very well be that a learned Deputy District Judge, who actually conducts stage 3 hearings, does have at least as an acute a sense of this court as to how to weigh the competing factors of the overriding objective in the context of that sort of case, which is obviously an extremely remote from the business of this court, the usual business of this court. So in my respectful submission, the point shouldn't be let in, but if it is let in, the court may have no hesitation in dismissing it for the reasons which I've offered. If I can just ask your lordship and your ladyship to excuse me a moment.
Yes.
Those are my submissions, unless I can assist the court further.
Thank you, Mr. Williams. That's been very clear. Thank you. Yes.
My lord, my ladies, I think I have 4 short points in reply. First of all, I should perhaps deal with the excitement I seem to have generated on the claimant side by suggesting that claims that drop out of the protocol that are of small claims track value would be subject to fixed costs. That may be more contentious than perhaps I suspected. It's not directly material to this case, so I just take the opportunity to make clear that is not in any sense a concession. Of direct materiality to this case, the question that my learned friend raised last of to what extent was this question of impecuniosity really in play. Can I go back, please, to the letter of the 4th of June at tab 3, pages 47 and 48 of the supplementary bundle. I think my learned friend really made 2 points on this. Firstly, that it didn't join issue over the question of impecuniosity, and also that the offer that was made shows that this Hussein point wasn't really being proceeded with. Now, as far as joining issue is concerned, this letter post-dated receipt of the witness statement, so I accept it was written with knowledge of what was in the witness statement, but it does enough in my submission to make clear that the witness statement is not being accepted at face value. If we look under the heading of rate on the first page, where it says the claimed rate is denied, the first statement is the claimant has not proven impecuniosity. And then if we go over the page, looking back where we were earlier under the heading of need in the middle paragraph, there's a clear request there for more than the claimant has already provided. The claimant is asked to evidence full and complete financial accounts to demonstrate and so on. So while it doesn't say in terms, we've seen your witness statement, we don't think it's enough, it does enough in these truncated proceedings that aren't being, certainly on the defendant's side, aren't being run by lawyers. In my submission, it does enough to put those who act for the claimant, who are lawyers, on notice that this is a real issue. And as far as the offer is concerned, it's not an offer which is made only under the heading of intervention. We see the offer is made at the end of this letter, and it's a comprehensive offer in all the circumstances. It may well be that in respect of a Hussein case, it's more generous than the defendant needed to be, but in my submission, they shouldn't be prejudiced for that. This is a letter saying we have essentially 3 issues with the fact that you are claiming credit hire. We pursue each of them, and we say that what you should be held to is the sum of £1,881. As for what happened at the hearing, I won't go over old ground there. I do say that the way it was raised was enough to raise it, but I do pray and aid here an observation of Lord Justice Flo in the McBride case. If I could ask the court just to come back to that momentarily at tab 8 of the authorities bundle. And page 148. It's at paragraph 80, where Lord Justice Flo said, I was not impressed by Mr. Turner's submission that the appeal on this point should be dismissed because the claimant's counsel failed to pursue the point with sufficient vigour or to seek clarification after delivery of the judgment. The fact remains that the judge erroneously failed to address the nil excess point in his judgment, and so on. And I say really much the same applies here, and that the answer is ultimately that the claimant was quite content for it to be taken to be a live issue at the hearing below. Milena Friend didn't say a huge amount about what is really the key issue here, the evidential standard that should be required within the protocol in order to make good an allegation of impecuniosity. What he said in essence was that the witness statement lacked implausibility, to use his own double negative, and that should be enough to get home. My fundamental submission, as the court will have, is that that is not enough outside the protocol, and it shouldn't be enough inside the protocol. But the comparison with Mr. Hussein's position is also noteworthy, because Milena Friend made good his submission in part by reference to the amount that was at stake. It's worth keeping in mind that Mr. Hussein's claim for credit hire was less than £6,000, a smaller sum than is being claimed in this case. And yet he was subjected to a fundamentally different evidential standard in making good that claim.
But in a different process.
But in a different process, of course, in a different process. But then there has to be a reason in my submission why the standard should be different. It's one thing to say that the processes are different and streamlined within the protocol. It's quite another to say that the substantive requirements of proof of a claim are different.
But it isn't the protocol. It's aimed, it's like it's going for a series of gates that close behind the parties as they agree. Liability not an issue, so you're in, agreeing this and agreeing, and you get to stage 2, and then you're just left. It's not at all designed to litigate major issues. No, absolutely, my lord. If you've got to stage 3... Get there, and if something's an issue, then the district judge,
yes,
as a rough and ready process, decides it. It's a very different forensic exercise to the one that Mr. Hussein's case was subject to.
Yes, and it could be said that this shouldn't happen, because if the process is working as it should, then claims that ought to come out because they need to be determined in a different way will come out,
yes,
and be determined in a different way. So one would hope that it wouldn't happen in the future after this case, that a case would get to stage 3 with this sort of limited evidence, and that the claimant wouldn't be asking the court to find impecuniosity on the basis of that evidence. But this case does raise directly whether that evidence should have been enough within the protocol, and of course for future cases, whether that evidence would be
incumbent
enough.
upon a defendant in a case such as this one? Statement goes in from the claimant. You say, well, it's nowhere near enough. It's just your word for this. We want to see it. And then that either generates a consensual process where you both have a look at it and agree a figure, or you say, no, we want to come out of the protocol. It's, I'm trying to avoid all these cake and eat and rough and smooth metaphors, but that's the nature of the process. You're either in that
Yes.
ready process, or if you really want the thing looked at in more detail, then you have to come out of it.
But what we then have to deal with, my lord, is the situation where the claimant says, no, I think I've done enough. I don't want to come out of the protocol. I'm happy with my bare assertion of impecuniosity. What then should happen when it comes before the judge at stage 3? I mean, that is this case, but it may be other cases.
The intervening moment is the acknowledgement of service, where the defendant can say, no, we don't want this to proceed.
Well, my lord, that then creates the situation, which is what my learned friend is really arguing for, whereby every case has to come out of the protocol because the defendant doesn't know what the full range of evidence that might be ranged against them is. In a situation like that, where you've got to the end of stage 2 and the evidence just isn't good enough.
Not with respect, it wouldn't be every case, because there may well be a significant number of cases where it's raised as it was here, and then the step that didn't happen in this case is the defendant at stage 2 says, right, let's have a look at this. Please, can you give us more detail, and we'll look at it.
Well, my lord, I would say we did in the letter of the 4th of June. I would submit that that was enough to require the claimant to go back and look again at what they had produced. But then there might be another case in which that clearly, very clearly happens.
Yes.
And the claimant just declines to engage. The question then is the defendant required to take it out of the protocol into a higher cost regime because of the claimant's failure to engage? Or can the defendant confidently go to a stage 3 hearing and say to the judge, we've taken the point, we've taken it very clearly, the claimant has given us nothing more than a bare assertion. At this point, should the judge say, impecuniosity is not proved? That's the particular situation that might arise. And we say is the situation in this case. And that does, the question does then have to be grappled with. Is there a different standard of proof of impecuniosity at that stage in the protocol compared with what there would have been outside it?
I understand.
That's the issue. And finally, my lord, my ladies, on what might happen at stage 2. There may well really not be a huge amount between us on this, because all we want, as I've said, is to be in a position to make an informed decision. If there are many cases, as my learned friend says, in which impecuniosity is obvious, then if that can just be made clear, that will cease to be an issue. It will stay within the protocol, and by that filtering process, on it will go to stage 3 without difficulty. Or if there is what sounds like an extreme case where there's a lever arch file full of financial disclosure, that's very obviously a case that's not suitable for the protocol, and that will come out. And if the claimant's solicitors, in the course of asking the claimant to amass this material, they take the view that this is going to be such a case, they always have that safety valve of the part of the protocol that allows them to say unilaterally, we think this is too complex, we'll take it out, and then at the end of the case, a judgment can be made about whether that was a legitimate decision or not. What troubles insurers is the prospect of this not sifting out during stage 2. So it comes down to the question of how many of the cards should the claimant put on the table at stage 2? And if it's all of them, as we submit, then no injustice will arise to anybody. It'll either be clear they're impecunious, or it will be clear it's a complicated case. The former can stay in, the latter can come out. What would not be a desirable solution is if the claimant needs to do nothing more than just say impecunious, and then effectively all cases potentially have to come out just so that that can be investigated, and that's what we're very keen to avoid. So if you just give me a moment. No, my lord, nothing else, thank you.
Thank you. Thank you, Mr. Carpenter, and also Mr. Williams as well. Right, so it's Mr. Bright now. Are you ready to carry on and present your appeal?
Yes.
Now, I should say that, Mr. Campbell, we received over lunchtime a copy of your revised skeleton, but having had a quick look at it, what you've very kindly done is put in the bundle references, but the text looks to me exactly the same as the version that we had. Is that right?
I'm grateful. Yes, my lord. In addition to the Court of Appeals correspondence, I addressed those points as well, my lord. But yes, it was just the numbers.
Oh, well, that's very kind of you, and we've got that.
I'm grateful.
Thank you. Yes, Mr. Bright.
May it please the court, as the learned silk, Mr. Carpenter QC has pointed out, Mr. Montclair Campbell to my right represents the respondent, Mr. Bourous, at first instance on first appeal and here today, and I, of course, am Dominic Wright, counsel for the appellant. May I check that the court has the appellant's PTA skeleton cross-referenced to bundles? I have spare copies if that's helpful.
Yeah. Yes, I have. No.
The court has indicated the court has my learned friend's replacement skeleton.
Yes.
The only of the two documents in this case are the bundles, I should say, are the core bundle, which is 175 pages, and the authorities bundle, which is 89 pages. The court doesn't...
I've got two authority bundles. One's 60 pages, and the other is, as you say, 89. So we'll use the 89 page one.
I have many copies of both, so if by the member of the Constitution.
Good, we'll get there.
Very briefly, in terms of the facts of this case, they're set out on page 1 of the skeleton, paragraphs 2 to 3. Actually, may I take an opportunity to ask if the court has had an opportunity to consider that skeleton?
Yes, we have. We have.
Very grateful. I won't rehearse those facts. And the judgment of His Honour Judge Hellman of the 12th of January 2021, which is the key judgment, is on page 29 in the core bundle. Of course, the appellant in this appeal relies on the grounds of appeal and the skeleton argument in full, but I hope not to just read out the skeleton argument. If I could turn the court to page 2 of the skeleton argument, at page 5, paragraph 5, the appellant is, of course, inviting this court to quash the decision of the circuit judge and restore the decision of the deputy district judge. And the overarching submission is that the claimants bear the burden of pleading and proving their claim on a balance of probabilities. Defendants do not bear the burden of disproving claims. The 6th ground of appeal, and I can turn the court to that if the court needs to be turned to it, but in short is that there's compelling reasons for the Court of Appeal to hear this appeal. The permission to appeal, I think, has found that, because it does raise an important principle. The other 5 grounds of appeal go to the central core issue as set out in the grounds of appeal. And that is that there's a real prospect of success because the judge of the judge hearing, the appeal judge, that's His Honour Judge Hellman, his judgment was wrong and or it amounted to a serious procedural irregularity. First, what is agreed? There's no dispute as to the substantive law. Hussein is not, which of course deals with profit-earning chattels, is not in dispute. For the court's note, the head note to that case is in the authorities bundle, page 62, at H Hotel 4. This is, of course, the basis of the first ground of appeal. Now, very briefly, turn the court to page 12 in the core bundle, please. And the first ground of appeal is that in order to recover damages for loss of hire, Mr. Bourous would have either had to claim for loss of profit or bring himself within an exception in that High Court binding authority. The circuit judge did not hold that one of the three exceptions was even asserted, claimed or evidenced, and therefore he should have held that the loss of profits should have been claimed, an exception should have been claimed and evidenced, or failing which the claim must be dismissed. If I may turn the court to the skeleton argument now, at paragraph, it's page 2, paragraph 6. For the court's convenience, of course, set out that the circuit judge was alive to this governing authority and cited it at paragraph 6. Moving to paragraph 7, he was alive to the central submission that I make here today, that in order to recover damages for loss of hire, he would have had to claim for loss of profit or bring himself within one of the three exceptions. And in my submission, that is why the Deputy District Judge was correct to dismiss the claim and the circuit judge erred. The respondent did not evidence that he fell within an exception on a balance of probabilities or on any standard at all. Just pausing there, a point which occurred to me with the learned silk, Mr. Williams QC, was speaking. CPR 27 dealing with small claims, of course, expressly disapplies the strict rules of evidence. There's no equivalent under the protocol. That's the first point. The second is, of course, the overriding objective. The parties must be placed on an equal footing, and the quid pro quo the court could take from the protocol is that defendants are denied the ability to meaningfully cross-examine, but claimants who have the time to think about, marshal the evidence, and plead their case must get it right. If the court would please look at paragraph 8 of the skeleton, the learned judge held that this governing High Court authority was not before him and that the case is irrelevant. Now, my learned friend's argument, of course, or submissions, I should say, at first instance on appeal, and in his skeleton argument, rehearsed that, and I'll come on to engage with that point. But of course, I've set out that Hussein hasn't been appealed or distinguished. Well, I set out now it hasn't been appealed or distinguished. And it does bind county court judges. Put another way around, what more is an advocate to do? Does an advocate not mention the High Court governing authority merely because it's not set out in the Stage 2 proceedings pack? My fundamental submission under first ground of appeal is that the Deputy District Judge correctly dismissed the claim, and there's four propositions which support that. The evidence established that he was the respondent, that is, Mr. Bourous was a private hire driver who used the car for private hire. The court will see that. I have citations here in the bundle, but that's not in dispute, and the circuit judge, in his judgment, notes it's not in dispute. In the context of a profit-earning chattel case, the burden of proving the entitlement to credit hire requires rebuttal of the presumption that the correct measure of damages is to compensate the claimant's loss of use. Without rebutting this presumption, there's no entitlement to credit hire. The defendant was able, or the defendant at first instance, the appellant now, was able to rely on the claimant's evidence that the car was a profit-earning chattel to submit that he wasn't entitled to credit hire. The defendant did not need its own evidence to found a submission that the claimant was entitled to credit hire, such as basic hire rates evidence. If this was not a profit-earning chattel case, a normal credit hire case, if I use that term, in absence of basic hire rates evidence, one's fixed with the credit hire rate or an intervention rate. But here, the default is not to rubber stamp the credit hire rate. The default is loss of profit. If the defendant commented to this effect in the Stage 2 proceeding pack, there could be no dispute with the evidence at the Stage 3 hearing, the claim for credit hire must be dismissed. And that takes me to my second ground of appeal.
Right, on the first ground of appeal, you are saying that the judge, sorry, I lost the grounds of appeal. That the judge should therefore have held the loss of profits should have been claimed, the exception should have been claimed in evidence, and the failure that meant the claim should be dismissed. Going to Judge Hellman's judgment, where do you say the judge was in error?
If the court would please look at page 12 of the core bundle.
Yeah, that's the grounds of appeal.
That first sentence, Hussein and EUI would have been the governing authority.
Yeah.
As the issue was not before him, the case was irrelevant. It remains the governing authority. And my submissions will come on to the fact that advocates have to raise governing authorities.
Yes, but it was, Ray, if you look at the district judges, I may be missing something, but if you look at the deputy district judge's judgment at page 129 of your bundle, at paragraph 5, the deputy district judge had the case of Hussein in front of him. And it's the bottom of the page, 129. Hussein was published in 2019. Now we're 2020. It's not new law in the sense it's not a case that was decided last week or the week before. Claimants and representatives expected to know the law. I feel have no alternative, despite the alternative pleading by the defendant and the invitation currently by the claimant to transfer the matter, than to strike it out.
Correct, and therefore the
circuit judge seems at page 39 of the bundle, paragraph 56, to have held that it was too late for the defendant to object to the claim for car hire. And the circuit judge seems to have been taking the view that although the district judge was aware of the case of Hussein, the matter hadn't been properly argued at stage 2, as I would understand it. So what do you say to the circuit judge's decision in respect to that? I got that right.
Court, bear with me just one moment, please.
Yes, it's to help you. It's the next sentence that the circuit judge says, the deputy district judge ought not to have considered the issue as it wasn't properly before him.
Well, in my submission, it was properly before him, because using perhaps an analogy, if there was a change in the law and it couldn't have been pleaded because the parties couldn't have been aware of it, is an advocate just to not raise that change in the law? And is the court obliged to rubber stamp something which is against the governing authority? If that's right, if advocates in that situation where there's a change of the law have to raise it, in my situation, when in my submission, when an advocate becomes aware of it, and I'll take the court to the email where my instructing solicitor emailed the other side and the court to say we're aware of this governing authority, particularise the position. This is an utterly different case to a deliberate ambush. There's no evidence whatsoever that the solicitor knew of this, was alive to the issue and thought, I will keep it quiet and I'll ambush the claimant at a stage 3 hearing with him. In fact, the opposite is true. Does that assist, President?
Not sure it does, because it wasn't the point wasn't argued, if I understood what went on, before the Deputy District Judge. The judge took the point of his own volition.
The Hussein point?
Yes.
No, that's not correct. Before the hearing, my instructing solicitor emailed the court and my learned friend's instructing solicitor attaching the Hussein authority. In fact, actually, may I just take the court to that email, please?
Yes, certainly. I mean, I know that happened, but I'm just trying to understand why the circuit judge did what they did. And on what basis you say they were wrong.
The court would bear with me just a moment. I apologise for taking my time.
Not in the index.
Yes.
I'm not sure I've seen it.
The way the circuit judge approached it was to say, well, what is the position when a new point is taken at the stage 3 hearing?
Yes.
Page 82.
Correct. Correct. It is page 82, and that is a point that I have to deal with. And there is a county court authority, a circuit judge that my learned friend raised during the hearing, which had not been filed and served, and that is the authority that he seeks to rely upon on exactly that point. And there's two approaches that the appellant takes to that case. The first is that it's not a profit-earning chattel case, and therefore it doesn't assist. But if it does assist, it's wrongly decided for reasons that I'll put forward before the court. But page 82 is that letter, which is is that email.
It's the day before the hearing.
It is. I believe it's the Monday before the hearing at 2 o'clock in the afternoon on the Tuesday.
And that's the stage
Which
3
is
hearing.
Monday,
Yes.
Monday at 9:36, if we're being precise.
Yes.
PM. Yeah.
Yes.
Yeah.
And the court will note, I hope, the third sentence. Notice of the hearing was only received end of last week, this email being sent on the Monday, and I received my client's final instructions on Friday.
Yeah.
There is another distinguishing fact between the appeal the court has just heard and this appeal, which is that the acknowledgement of service does request that the matter is taken out of the protocol process. And my submission before the Deputy District Judge was twofold. First, that the case was incompatible with this High Court authority, and therefore the court could not make an award in favour of the credit hire. But secondly, in the alternative, it should be transferred. My learned friend's case was award the credit hire and, in the alternative, transfer it. And of course, the appellant is very alive to the idea, of course, the court needs to do justice in this case, and of course give guidance to other litigants in other cases as to how situations such as this can be resolved justly and proportionately.
I think I've now got it. I think I did have it earlier this morning, but it got back to me. understanding. The circuit judge's point is that, okay, the Hussein case exists and the defendant might have an argument about it, but it wasn't raised at stage 2. And under the protocol, if you haven't put your cards on the table at stage 2, you can't pull out another card, a new one at stage 3. And so the deputy district judge simply should have ignored the point within the protocol.
In my submission, of course, common law based on precedent, it wasn't an option for a circuit judge to ignore a decision of the High Court. It's not pleaded, but it's the governing authority. An advocate turns the court's mind to it. It's an envious position to be in, and of course, in the bundle and in due course, I'll reference the practice direction of the citation of authorities, that it's in fact one's duty to draw an adverse authority to the court's attention.
But only if it's relevant to the issues as they are at whatever stage you are in the process.
And as to stage 2 process and what was an issue, if we turn to page 135, this is the court proceeding pack. And there we have car hire. And there you have the value claimed, which is 11,800 and something. And the defendant's response is, we can only consider a rate of 153.36, including VAT a day. And the short point of that, as I understand it, is that there was no objection being taken in principle to the claim for car hire. It was the rate. And again, as I understand it, but I'm really willing to be corrected, that was the point the judge was taking when he said at paragraph 56, in the present case, the defendant did not object to the claim for car hire at stage 2 on the ground that the claim was disallowable in principle because the claimant was a taxi driver. And then we have this, but objected only on the ground that the amount claimed was too high. And I think that is probably a reference to what we see at page 135.
Yeah.
So that's the point, you see, and that's the factual basis on which I understand the judge to be saying Hussein isn't applicable because the point wasn't taken.
To that point, my lady, there's 4 possibilities in terms of pleading or setting out your cards, your store, perhaps I should say. First, that no party has to set out their store. And I don't believe any advocate is saying that that's the case. However, the proceedings pack are expressly not pleadings.
Well, they're not pleadings, Mr. Bright, but what they are documents that have been set out in accordance with the protocol, and it is a protocol which is strict in its form, and there is a reason for that, which goes to the particular process, the truncated process, and the costs that flow from it. So there has to be observance of the protocol. And in the protocol 7.4, the defence has to set out its case. And that's what we see at page 135.
Which takes me, my lady, to my second scenario. That only the claimant must set out the claimant's case, because of course it's not in dispute that the claimant has the burden of proof. Whatever the standard is, the claimant has to prove something. Now, of course, because of the equality in the overriding objective, the equal footing, no one can sensibly be saying it's only the claimant that needs to set out their story. But my learned friend's point, I understand, and the court's, the circuit judge's judgment, holds the defendant to account for not setting out the defendant's store, which comes chronologically after the claimant has failed to set out the claimant's store. And it's important for the reasons that the court has heard, because defendants need to know what they're responding to. So a defendant cannot positively say, I'm going to accept that you've lost business, because there's no assertion at all that any business has been lost, or of impecuniosity, or of need to hire. And therefore, if it's incumbent for the defendant to respond, then the defendant has to be able to respond to something.
Well, it could. It could say, in respect of that claim for higher charges, we do not accept the claim in principle. One short sentence would have sufficed. It didn't.
My lady, yes. And before I come to the fourth scenario, to that, if the Court of Appeal were to say, in this scenario, where there's nothing in terms of pleadings and nothing in terms of evidence within Hussein, the defendant still has to set out the defendant's store, then you get a precedent kitchen sink boilerplate letter saying we dispute every issue, every possible issue, that hasn't even been pleaded yet. In my submission, that is why the Court of Appeal in the cases relating to Part 7 proceedings have said it's incumbent on a claimant first to set out the claimant's position so that the defendant can meaningfully engage with that to narrow the issues.
If defendants did that, then the court or the claimants would simply say, right, we're off. We're not any longer in this low value, low fee protocol. We're off to have it all litigated in Part 7. So that they wouldn't do that. Under the protocol, I'm looking at paragraph 7.66, which is in the big authorities bundle. Have you got that, or you've got it separately?
Yes, 166.
My ladies and I have got it at tab 13, page 238.
238. I'm there.
Yep, we are. We're coming. 238, 766. Under the general heading, failure to reach agreement, this is at stage 2. 766, comments in the court proceedings pack form must not raise anything that's not been raised in the stage 2 settlement pack form. That, and I think there was a similar provision, I think we were shown, that applied to defendants. But the basis of the protocol is that all of the points are raised in stage 2. It's then a sealed unit, and it moves on to stage 3 because it is a rough and ready process.
Correct.
So what room for manoeuvre in that is there for the judge or the parties to introduce a further point at the eve of the hearing?
Well, that takes me to the fourth possibility, the fourth scenario, which is both parties have to set out their store. Both parties have to set out their store.
But the defendant didn't on this point.
That's correct. The defendant did not set
Right.
out Hussein or profit earning chattels, the need to prove impecuniosity. But if it's right that, and of course, His Honour Judge Hellman in his judgment mentioned if the defendant had have set this out, then the claimant would have produced further evidence to make out their claim. I apologise, I've just lost my train of thought. I apologise, I've just lost my train of thought.
Don't worry, it happens. I've forgotten. It happened to me a number of times.
That happens to me a lot too.
Oh, yes, if the objection, if my learned friend's best objection, if the respondent's best objection to the defendant is, okay, that's the governing authority, okay, we may not have pleaded or evidenced anything, but you should have told us, you should have put us on notice of that. If that's right, then, and the defendant, or the appellant in this case, has committed an error by not setting out the defendant's store. First, was the claimant under an obligation to tell the defendant that the defendant hadn't set out its store? Of course not, in the same way as the defendant's not under an obligation to tell the claimant you haven't pleaded your case. Secondly, there's no sanction which is prescribed in the protocol as to what happens. The court has 3 options. Option 1, rubber stamp the credit hire claim in full, and make no mistake, these are very high credit hire charges. Option 2, dismiss the claim, dismiss this part of the case. Or option 3, something else. Further directions, allowing witness statements to be put in, or transferring in accordance with my alternative submission, in accordance with the acknowledgement of service, and properly setting out why it should be transferred. In my submission, to railroad through a claim when the claimant has the burden of proof, and the defendant doesn't have to prove or disprove anything, in my submission, that has to be wrong. If both parties have committed an error by failing to set out their store, the claimant's error comes first, and it requires, of course, the claimant's error compounds the defendant's error. The only reason, of course, the defendant can be impugned for not saying, why haven't you pleaded your case in accordance with the governing authority? that only arises because of the claimant's prior error. So the appellant merely invites the court to find if there were errors committed on both sides, the one first in time caused the latter, and in any event, the most draconian sanction, the court has heard from the learned Silks for the defendant, is that the claimant pulls it out of the protocol and the defendant is stung with costs. Well, okay, that was the appellant's alternative submission. Let's pay the alternative costs and have the matter transferred. So in my submission, the appellant couldn't have done more. The appellant, when they were seized of this matter, raised it to the court's attention, as of course is an ethical duty to do, under secondary legislation, obligation under the civil procedure rules, and attempted to assist the court to apply the correct law, and gave 2 submissions and said, District Judge, it's up to you. And looking at the appeal, the first appeal, it's only the issue of not awarding the higher rates in full, which is the subject of that second appeal. The respondent could have appealed the failure to transfer and thereby allow further directions and allow the claimant to basically get their stall together and succeed on this very high credit hire charges point. And therefore, of course, in my submission, it is right, it must be right that both parties have to set out their stall with their cards upon the table approach, this 4th scenario. But of course, even if the defendant has committed an error here, of course CPR 3.10, it doesn't, because there's been an error in procedure, it doesn't necessarily invalidate anything. It's for the court to decide what happens next. The most draconian sanction is either to award the claim in full or to dismiss the claim. Which takes me conveniently to my 3rd ground of appeal, having addressed the court on my 2nd ground of appeal. Of course, again, this is in the core bundle at page 13, now looking at paragraph 3. Which is equating the proceedings pack with effectively formal pleadings. And of course, I'll come on the 4th ground of appeal. I apologise, the 5th ground of appeal deals with the issue in Mulholland and what authority a county court decision had, and whether it should be followed, etc. But that decision, which I'll give the court the reference for in due course, says that defendants must adequately particularise their defence in full, etc. Well, as the learned Silk, Mr. Williams at QC submitted, if claimants can't be expected to set out everything, then one should plead facts and not law. Is an insurer in a stage 2 proceeding pack obliged to say profit earning chattel or Hussein or the neutral citation or where it's cited in the law reports? How much is one expected to set out? But turning to that 3rd ground of appeal, if I could ask the court please to look at page 5 of my skeleton argument. And of course, at paragraph 22, it's conceded. It may be desirable that a defendant sets out the precise nature of its defence, but the question is, what follows? A sanction isn't prescribed, it's for the court as to what sanction, and is it a proportionate sanction, or is it the most draconian sanction? Turning over the page to paragraph 23, there's that reference to the ethical duty of advocates to draw an authority to the court when it's not cited by an opponent and is adverse to the case being advanced. Well, in my submission, that applied fair and square at that straight before, And at that stage 3 hearing, which is why it was raised, and that authority was filed and served as soon as possible via email. Turning to paragraph 25, can it really be right that a court is stopped from looking at what everyone talks about as the governing authority? And even if the defendant is not allowed or debarred or is stopped from citing that authority, wasn't my learned friend, wasn't it incumbent upon another advocate to say, there's a governing authority here, my case is...
This is very much the same argument in a different way, under grounds 1 and 2, isn't it?
Yes, and they all fall under there's effectively 2 overarching grounds in the grounds of appeal. The second, the second head, I suppose, is the ground 6, other compelling reasons, serious issues of practice and procedure, and of course...
That's not with respect, that's not a ground of appeal, is it? That's a reason for granting permission.
Yes.
To appeal.
And so therefore the 5 grounds of appeal do all fall under the same head, as I hope I've pleaded, although perhaps...
Yes. So these 5 grounds are effectively snapshots from different perspectives of the overall point you seek to make.
Yes. Yeah. This County Court Authority of Mulholland, for the court's note, I set the facts out in a scoping argument before the circuit judge. If the court wished to cast their eye over it at another time, it's page 48 in the court bundle, paragraphs 38 to 40. They're the issues that were before that court is set out, and what the court found is set out.
Right, well,
I apologise if the court would give me just 1 moment. I apologise. I've written a lot of written notes, and I'm struggling to keep up. I apologise.
don't worry.
Yes, the distinguishing facts of Mulholland I've set out for the court, but the court need not actually, of course this is the Court of Appeal and that's a county court decision, but that case does not deal with profit earning chattels, and the big so what of that is in a normal credit hire case, as was the case in Mulholland, well in the 4 appeals before the circuit judge in Mulholland. If the defendant doesn't raise impecuniosity, or impecuniosity is not an issue in any event, and there's no basic hire rates evidence, the credit hire rate will be awarded. That's the sanction, that's the default. But here, this case is different. The cause of action, as it were, in respect to profit earning chattels, requires either one to plead and prove loss of profits, or an exception in Hussein. And without that, without one of those 3 exceptions, one is stuck in loss of profit. And so it's not, perhaps in a credit hire case, not taking issue with impecuniosity may be is of limited consequence. Whereas in this case, it's fundamental. It is an absolute defence. And of course, I've made the submission, but in other words, if Hussein was set out in words in that stage 2 settlement pack and the claimant did nothing else, it would be an absolute defence. There'd be no argument. So the only objection to the defendant could be, why didn't you raise this earlier? And was it an ambush? Well, in my submission on the basis of that email, it wasn't an ambush. It was raised.
No, well, we've been over that ground, but what's the? I get confused, but the ground 3 doesn't mention Mulholland as far as I can See, we're still on ground 3, aren't we? And yet your skeleton goes to the citation of authorities and I think starts to make the point about Mulholland.
Yes.
Or is that citation of authority, that's the duty to bring Hussein to the notice of the court?
So it was paragraph 21 in the skeleton on page 5 I was referring to. The circuit judge found consistence in that authority of His Honour Judge Friedman, that county court
Yes.
authority.
So what's the point you seek to make about that?
Yes, if the court would bear with me just a moment, yes. Paragraphs 38 to well, this does roll into my 5th ground of appeal, and therefore the skeleton engages at paragraph 34 with Mulholland.
Right.
The first question for the circuit judge was whether he could actually look at it because of the practice direction on the citation of authorities, and therefore to be able to look at it, he had to be satisfied that there wasn't a decision of a higher level of authority on the issues. And
I'm not sure it's a very helpful way to put it. To say, in order to be able to look at it, he had to do things. I mean, surely, in order to decide whether the case could be cited consistently with the practice direction, the circuit judge had to read Mulholland in order to see what Mulholland decided, in order to be able to say whether the other cases decided the issue instead.
yes, it's a clumsy way of phrasing it.
Yeah. So you accept that the circuit judge was entitled to read Mulholland.
He read it, but he didn't follow it. And that he makes clear at
Yeah.
paragraph 57.
Yeah.
He said, I reached this conclusion independently of Mulholland and Hughes, albeit through a similar chain of reasoning.
Yes.
So when you say, for example, at paragraph, I think it's 21 of your skeleton argument, that he followed a county court decision, he specifically didn't.
In my submission, he gained assistance from that, and my learned friend's skeleton argument for that first appeal, and in fact in this appeal, relies very heavily on that county court authority, and therefore I took, of course the appellant takes the view that the appellant needs to engage with that authority, but
isn't the right approach to ask whether the reasoning in Mulholland, number one, is correct, and number two, if it is correct, whether it was relevant to this case?
yes.
But even then, as my lady has just pointed out, the circuit judge in this case expressly said that he wasn't following Mulholland. So the real issue is, was the circuit judge's approach in this case correct, regardless of Mulholland?
Yes, it is.
All right.
And effectively, the approach is, if something is not raised in stage 2 by the defendant, it doesn't matter what the claimant's stall looks like, that claim will be allowed because the court doesn't have a sort of gatekeeper function with claims. If something isn't put in issue, even if it's contrary to the governing authority, there's nothing the defendant can do.
Right.
In my submission, that can't be correct.
Right. Thank you.
The 4th ground of appeal, which I haven't yet touched upon, is expanded upon in my skeleton argument on page 6
Yes.
at paragraph 27. Well, at paragraph 27 onwards. The short point is, if one has an absolute defence, is one obliged to tell the other the other party that you have an absolute defence. Let me be clear, this is not a case where the defendant took the view, I won't cite this governing authority and ambush someone. But even if that was the case, to the point, well, if you had have raised the governing authority, which we should have been aware of when we pleaded and issued the claim, is it incumbent on defendants to set out they have an absolute defence, and then claimants will put in further evidence, the claim, or perhaps on the basis of the appeal the court has just heard, a couple of sentences in a witness statement, I was impecunious, and then very high credit hire charges would be awarded, and the defendant would have to pay the costs thereof. Is that right? Of course, those two cases, Barton and White Hassel and Phoenix Healthcare, are cited. And Phoenix Healthcare was relied upon at first instance, and the district judge does engage with that point. The court will have seen that in the transcript of the judgment, no doubt. But if the court hasn't, I've set out the reference in bold in the skeleton argument. The fundamental point of this submission is that the circuit judge didn't engage with the point, the legal point, not the factual point, but the legal point that is analogous in the appellant's submission. Of course, and as is set out in the skeleton, the facts in Barton are different to the facts in Phoenix Healthcare. Yet Barton, that Supreme Court case, was cited in Phoenix Healthcare. Yes, there's material similarities, and Phoenix Healthcare, I believe that the Lady Justice sat in that case. Yes, there's material, factual similarities, but there's also differences. One had a litigant in person, one had solicitors. I know at the time there was a few points that, well, in fact, the first point was that the court asked myself and my learned friend, Mr. Campbell, to consider the skeleton argument for Mr. Williams QC on the Lagden and impecuniosity point.
Yes.
I had a few short points on that. I wondered whether, I appreciate the time, but I wondered whether...
No, well, we certainly we'd carry on. And then I don't know how, I know certainly some of you have come a distance, and it may be sensible to think about whether we should finish the hearing today. I don't know how long, Mr. Campbell, you think you might be in response.
My lord, I informed my learned friend earlier about 45 to 50 minutes.
All right, we're probably beginning into tomorrow then. We'll get to see where we are at the end of your submissions.
So the court explicitly asked the parties in this appeal to be alive to 2 points. One, they may field, they should be prepared to field questions on the appeal the court has just heard. And secondly, to submit whether the submissions in paragraphs 28 to 37 of Mr. William QC's skeleton argument are relevant to the appeal, and if so, how far?
Yes.
The court has my learned friend's skeleton, and the court has his submissions on that as to how far it's relevant or not. But in summary, I have 6 submissions, but they are brief, and they conclude with a simple point. The first is that Lagden, Patney, Stevens and McBride didn't consider profit-earning chattels. Secondly, Hussein is the leading authority in relation to profit-earning chattels, and paragraphs 10 and 16.2 of Hussein, yes, in paragraphs 10 and 16.2 of Hussein, Lagden is cited and relied upon. So Mr. Justice Pepperell was aware of that case. Thirdly, in Lagden, Patney, Stevens and McBride, there was no ability to mitigate loss by claiming lost profits, which is the other side of the coin to credit hire profit earning chattel case. There was no other choice but to hire a car. In the instant case, where there is a profit-earning chattel, there is an ability to mitigate loss. That is by claiming lost profits. In other words, there's another way to reasonably meet the needs of the claimant for the purpose of making good the loss. Fourthly, the burden is on the claimant to plead and prove impecuniosity, and the two recent Court of Appeal authorities have been cited by Mr. Carpenter QC before you, so I won't rehearse them. But of course, Zurich Insurance in footnote 2 that the court saw on page 89 of the Yousaf authorities bundle, paragraph 37 on page 98 of the same bundle, and in Derija, page 164 of the same authorities bundle at paragraph 4, then later page 165 at paragraph 7, and page 177 at paragraph 67. Fifthly, and I've made this point, but this is a submission in relation to the skeleton argument, that where there's no pleading or evidence of an exception, the claimant with a profit-earning chattel is limited to claiming lost profits. Therefore, there's no need for basic higher rates evidence. The defendant can merely point out you haven't pleaded or proved an exception, and therefore you're fixed with lost profits, which you haven't pleaded or evidenced. That lack of BHR would only result in the issue of impecuniosity being academic, where the only claim is for credit hire. And there's no issue, therefore, as to measure of loss. Sixthly and succinctly, therefore, of course I adopt the submissions of my learned friend, Mr. Carpenter QC, under his heading Credit Hire and Impecuniosity Generally. And for the court's reference, that's page 26 in the core bundle for the Yousaf appeal, paragraph 16 to 21. I wanted to show the court that I've done the work. I don't just adopt my learned friend, Mr. Carpenter QC submissions. That's how I get there. The court asked a question and I had to answer it. I apologise for going 5 minutes over the time.
No, well, we quite often go until extravagantly 4:30 or so.
Mr. President, may I not formally conclude my submissions? May I take a moment, perhaps
yes.
over the...
But is it sensible to rise now? Yes. Yes. So we'll rise for the day. Now, just out of interest, has it got any warmer, or not, or is it just we've got used to it?
I might have done.
Well, I can't tell because I put on an extra layer. But, well, if it has, I'm grateful to
As I
it.
said, like a lot of people, I was in the unaccustomed position of driving into London at an ungodly hour this morning, so I've been quite glad of the cold to keep me awake.
Yes. Well, there we are. Good
That's
one.
not. That's certainly not an adverse comment on any of my learned friends' submissions.
I'm sorry you were put into that position. So we'll sit again at 10:30.
Yeah.
10:30, and we'll obviously aim to finish within an hour and a half, I'd have thought.
Very good.
Thank you.
When you were still on live stream, time is 9 seconds.
Yeah, thank you.